So there was an interesting case this week concerning restraints of trade and interlocutory injunctions. So what happened was there was an employee who worked as an associate director of accounting at Blue Rock, which is a professional services and accounting firm. She got poached by Nexia and moved across there as a partner in accounting. And Blue Rock had some concerns that she was going to poach clients at Blue Rock for Nexia. Now, her employment contract with Blue Rock contained a standard restraint of trade prohibiting her from soliciting clients at Blue Rock for a period of 2 years. It also confirmed that Blue Rock was able to obtain an injunction in connection with that restraint of trade, and they sought to do just that. So what was happening is they sought an interlocutory injunction, which is an injunction that just applies for a very brief period of time until such time as a proper court hearing and decision has been made concerning whether or not the restraint of trade is enforceable to start with. So obviously, as you can imagine, when somebody leaves and moves to a competitor, you want to move on your restraint of trade really quickly, but you might not be able to get a court date and a decision on whether or not that restraint of trade is enforceable for some period of time, at which time it could actually be all too late. The person might have already poached all the clients and the damage might be done. So what happens is people seek what's called an interlocutory injunction, which can be made very quickly, and you sort of provide less evidence, I guess, compared to a more fulsome case and hearing, which would happen down the track. And they just sought that, Blue Rock sought that order, that interlocutory order, and it was rejected by the court. And the reason why it was rejected is that the court said there was not enough evidence that the employee was going to breach the restraint of trade in order to grant it. And what Blue Rock's evidence was first of all, the employee had allegedly said, which she denied, to another employee at Blue Rock that all the clients were going to follow her. And then second of all, she'd done a LinkedIn post which announced that she was moving across to Nexia, and it invited everybody to connect and collaborate with her and stated her new email for Nexia. So the court said that that was not enough evidence that showed that she was going to actively solicit clients across for Nexia. And they also said in connection with the statement that she might have made to a colleague that the clients would follow her, they said that's not really her soliciting clients per se, even if that happened to be true. So it's a good indication as to what evidence you will need in order to actually get your interlocutory injunction across the line. You're going to need actual substantive evidence of somebody taking steps to solicit clients, as opposed to this more general evidence. The court also indicated as well that they thought the 2-year restraint was going to be too long, and that was because the employee was a associate level director as opposed to a partner at Blue Rock. So, perhaps a 2-year restraint might have been more appropriate if the employee was more senior.